I, Rashid Shakir, together with my learned junior friend Ming, appear on behalf of the appellant, in this case Mr. Charles, and I'll be addressing the first issue of this appeal, which is duty of care, and my learned friend uh, will respond to the second ground of appeal, which is contributory negligence and impecuniosity. May I briefly, before I proceed, would my lord would like the brief summary of the case?
That would be very helpful.
Appellant Charles bought a house for £480,000 on the reliance of the respondent's evaluation that was conducted prior to the sale. At first, appellant was willing to pay $400,000, but upon seeing the evaluation, he agreed to pay $480,000. As a result, he suffered damage because the house that he bought had serious structural damages, and he suffered a loss of $180,000. Appellant submits that the respondent owed a duty of care to the appellant when undertaking the evaluation of the house, which appellant eventually bought in reliance on the accuracy of the report. First, in my argument, I would like to address the general rule recognizing this courts, as well as stating the specific
Counsel,
rule.
you said that your client relied on the valuation. Did the valuer even know who your client was at the time of rendering the valuation?
No, he didn't know. However, it was established by the law that he should have known that his report will be relied on for the mortgage purposes, and the subsequent, basically the purchaser would rely on it, rely on the report.
So it would apply to any purchaser regardless of how far into the future the property is actually sold?
No, my lord. It will be only as the Lord Griffith, in his opinion in the Smith case, noted that the duty of care without contractual relationship will be extended only to the first purchaser who relied on this report. Any subsequent purchasers will be excluded from the action against the evaluator. So, as a general rule goes, your lordship's house found such a duty of care to exist in the two cases heard together, Smith against Bush and Harris against West Forest District Council. In his decision, Lord Templeman, on page 843, said that the common law imposes a duty on the person who carries out an operation, an obligation to exercise reasonable skill and judgment, care when there is no contract. He further stated that where the relationship between the operator and the person who suffers injury or damage is sufficiently proximate, and where the operator should have foreseen that carelessness on his part might cause harm to the injured person, the operator is liable in the tort of negligence.
Are they sufficiently proximate here?
Yes, my lady. Appellant submits that they are sufficiently proximate here, because the valuer, as the further Lord Templeman noted on page 847, the valuer assumes responsibility to both mortgagee and the purchaser by agreeing to carry out a valuation for mortgage purposes, knowing that valuation will probably be relied upon the purchaser in order to decide whether or not to enter into a contract to purchase the house.
Counsel, how do you address that the joint cases that you rely on involved somebody who was getting a valuation through the building society and was actually paying for the valuation? Here, your client didn't pay for the valuation.
My lord, I think this is irrelevant because over here, in the instant case in front of us, it's a duty owed by the evaluator to the purchaser, and as qualified professional, Mr. Bent should have known that his report could be relied on if the purchaser would be satisfied with the report and would proceed with the purchase. There is overwhelming probability that the purchasers would rely on the correctness of the report in making their decision to buy the house.
Did the valuer even know at the time of making the valuation that it was to do with buying a house? I mean, he was simply asked to do a valuation, was he not? And then
Yes,
later
but
that valuation was used.
yeah, but the main purpose of doing evaluation is for the purpose of mortgage, and he should have known that his report will be used for the purpose of mortgage, of the sale of the house.
Okay, so you accept that he didn't know. You simply say he should have known because that's normal.
He should have known. This is norm, and statistically, 90% of the purchasers would rely on the report and would not conduct independent survey. You can find this statistical evidence from your Lordship's House judgment in Smith case by Lord Templeman on page 852.
But counsel, wasn't that a home that was valued at a much lower rate? That we wouldn't expect people to get multiple valuations. I mean, how does that apply here? Shouldn't your client have to get his own valuation? I recognize that your learned colleague will address this. But how does the amount of the house valuation play into this?
Amount of the house? It's a moderately priced house. That's why the appellant concedes that he didn't have enough money to conduct his own survey, and is said only 10% of people who purchase the house will conduct their own survey. 90% of the cases they rely. So it follows that that the respondent was responsible for knowing that his evaluation would be relied on.
You don't think the appellant's case would fall into the 10% minority where they're higher priced and we would expect somebody to then get their own valuation?
As a Lord Griffith in his judgment in the Smith case noted that there's high that's the only person who will suffer damage in case there is a negligence will be purchaser. That is why the purpose of the evaluation is for the sale purposes, and in majority cases the only person who will be suffering injury will be the plaintiff who is trying to buy a house.
What about the seller? If he undervalues the house, the seller could suffer. In this case, the valuer, really his duty is to the seller, his contract is to the seller, and any possible buyer is just simply too far away to have a duty owed to him.
It is true that because of the contract, the evaluator has a responsibility to the house owner. However, if in your hypothetical, my lady, if he doesn't like the price, he could hire another evaluator to evaluate his house, or he might sue him. However, it's not the case in front of us. In front of us is a case where there is no contractual duty, and if there was a contract between there is a contract between the seller and the evaluator. So in that case, it's a prima facie case of negligence. However, in this case, it's completely different facts. So the facts of today's case are no different from your Lordship's opinion cases of Smith and Harris. Seller hired an instructed professional evaluator who was respondent in this case to conduct evaluation of his property for the purpose of sale. Respondent knew exactly for what purpose the report is being made. He also knew that the house valuation will be passed on to the purchasers. As my learned friends for the respondent, they would argue that Kapar controls, which is also your Lordship's House case. However, this case is distinguishable because the plaintiff was a company, limited liability company, who after reviewing defendant's audit report decided to invest in a fidelity company. The court distinguished that there were many shares, hundreds of shares, and it would be wrong to hold an auditor liable to every single possible investor that would rely on that report for the whole year. My time is finished. May I
Finish this point.
Yeah, may I finish this one? Thank you. The decision correctly did not expand the duty of care established in Smith to world at large. As as Lord Griffith said in his opinion, it will be only expanded to the cases such as Smith, which is no different from our present case. Thank you.
Thank you very much.
May it please your lordship, I shall be responding to the first round of appeal and submit that the respondent owed no duty of care to the appellant. Your lordships, may I first ask you if you require a brief summary of the facts?
No, thank you. We have a
In proceeding to the substance of the appeal, I have 3 submissions. First, that for a duty of care to exist, there must be reasonable foreseeability, proximity between the parties, and it must be fair and just to impose liability. Second, that foreseeability and proximity have not been established in the present case. And thirdly, that in the absence of these first 2 factors, it is not fair or reasonable to impose liability on the respondent.
Are you accepting that if those 2 facts have been established, it would be fair, just, and reasonable in these circumstances?
Your lordship, not necessarily. However, since we submit that foreseeability and proximity have not been established in this instance, we did not proceed further into that analysis.
Okay, all right. Risky business, but
Indeed, I concede.
fortune favours the brave.
With your lordship's permission, I shall move to my first submission.
Please do.
Specifically in relation to economic loss caused by the advice or performance of services, there must be an assumption of responsibility and a reliance upon that assumption of responsibility. As such, a duty of care may arise under the voluntary assumption of responsibility or under a statutory obligation, as found in Smith and Bush reported in the
But
official.
counsel, isn't it foreseeable that if a valuer issues a valuation on a property, that somebody who's going to purchase it downstream would rely on it, and if that valuation is negligently done, isn't it foreseeable the purchaser would suffer a loss?
Your Lord, I understand that point. However, foreseeability, in order to have foreseeability, you must be able to identify a sufficiently limited class of persons that are to be foreseeable in order to avoid unlimited liability, which certainly isn't a precedent that we would want to set either. So it is our submission that prospective purchasers of a home are not a sufficiently limited class, as arguably the home is for sale to the public at large, the world at large. So again, it isn't foreseeable in this instance.
What do you make of your opponent's argument? His argument was that he posits a narrow rule that applies only to the first purchaser of the home, whoever that may be. That seems to be a limited class.
I understand my learned friend's point. However, it has also been found that a duty of care is owed specifically when considering the circumstances, the age and the price and the locality of the home. Surveys can imply that there is going to be reliance. So to that point, in the present case, it's clear that the appellant did not have the requisite hardships to kind of qualify for this indefinite reliance. So just because there is going to be a first purchaser doesn't mean that first purchaser is not going to have their own valuation done, as it is most certainly in their interest to have their own valuation done. To my next point, that for a duty of care to exist, that there must be reasonable foreseeability as well as a close and direct relationship of proximity between the parties. While there's no bright line test for proximity, it's generally established upon the condition that the injured party is a person directly intended by the maker of a statement to rely on that statement in a specific transaction of which the maker knows and for the purpose for which the statement is being made. That test of proximity is established in Caparo Industries and Dickman at page 610, which is also the gold tab at page 2. However, kind of the first and third of these conditions may be relaxed if the injured party is a person whose actual existence, although even if not named, the maker knows and to whom he or she believes that the statement will be communicated to, and who it is likely with a high degree of certainty will act upon the statement.
Isn't that true in this case, perhaps?
Your Lady, we submit that it is not true in this case. In the instant case, we submit that the facts are analogous to those in the Caparo case, in which it was established that no special relationship existed between Caparo and the auditors, as the accounts were evaluated without a specific transaction in mind, and the ability to inspect the accounts and the chance to buy the shares were enjoyed by the world at large. So,
well, that's not true in this case, is it? I mean, the world at large can't come along and view this valuation. I mean, it's not public in the same way
correct.
The accounts of the revenues is semi-public.
I agree, my lady. We submit that at the time the valuation was made, that the respondent knew that the purpose of the valuation was to put the house on the market, and arguably anybody who could come along from around the world could purchase that house. However, there was no specific transaction in mind at the time the valuation was made, in that no specific buyer had presented themselves, nor was it clear that the valuation would be communicated to a purchaser or a buyer at all, more or less that the valuation was going to be used to just put the house on the market. Further, we submit that in the instant case, the facts are distinguishable from those in Smith, as the case turned on the facts that the facts in Smith are that there was a survey completed by an employee and there was reliance on evaluation of the house, and the property valuation said that no essential repairs were needed. It was later discovered that repairs were needed. However, our case is distinguishable in that in that case, the valuation was given with full awareness of the nature of that transaction, that the house was being sold, and that the advice would be communicated directly to that purchaser. And in addition, the purchaser paid for that valuation as well, and it was known that there was a high likelihood that the injured party, Ms. Smith in that case, would rely on that valuation.
Does it really matter that the valuer know the specific person? I mean, doesn't it stand to reason that the valuer is going to know that a purchaser is going to rely on this valuation?
Your Lord, I understand your point. However, we would submit that in imposing a duty on the respondent to any purchaser that comes along opens up too much of unlimited liability, and that there's no proximity, as the contractual relationship here was between Anthony, who sought out the valuation, and it could be said that there may not be a purchaser for some time, or again, as discussed previously by both myself and my learned friend for the appellant, there are facts on whether or not the appellant was actually going to rely on that valuation, and there's no facts to suggest that, as established in the Smith case, that you can have foreseeable reliance when someone is of modest means and cannot be expected to have their own valuation. But again, we would submit that it's a liability limiting vice in order to establish foreseeability and proximity of those purchasers instead of just establishing a duty strictly based on the fact that he's an evaluation expert.
You said, Council, that there could be unlimited liability, and that's a good reason to keep it very strict and that kind of thing. Of course, in Caparo, they were talking about shareholders, of which there are potentially unlimited numbers, more or less, could be tens of thousands. In a situation such as this, there's really only going to be one buyer of a house, isn't there? So if we do find a duty of care, liability is always limited just to one person. Does that affect your argument at all? Is that a stop?
Yes,
You
like I see it,
just
like
answer that. You can answer my point and then stop.
So we submit that without the knowledge of that purchaser or the reliance on that purchaser of the valuation, and without viewing the purchaser in light of other circumstances and without a direct contractual relationship, in another way of limiting that liability, that no duty should be owed.
Thank you.
Thank you.
Thank you very much.
May it please your lordship, as stated by my lawyer senior, I shall be continuing the case for the appellant and shall be dealing with the second round appeal, which are contributory negligence and impecuniosity. I submit to you, my lord, that Bent was liable for the damages arising from Charles' impecuniosity. In proceeding to this substance of the appeal, I have three submissions. One, the particular rule established in Liesbach is not applicable to the incident case between Charles and Bent. Two, as held in Alcoa, the proper test in determining whether damages arising from Charles' impecuniosity were recoverable should be whether or not they were reasonably foreseeable. And three, my lord, Charles did not breach his duty to mitigate when he declined to obtain his own valuation because he could not afford to do it. With your lordship's permission, I shall move on to my first submission. For my first submission, I'll be discussing the case of Liesbach. Before I proceed, would my lord like a summary of the case?
Yes.
In Liesbach, the defendant had caused the total destruction of plaintiff's treasure. Plaintiff had a contractual duty with another party to perform dredging work. However, plaintiff could not afford to buy another dredger. Therefore, plaintiff was forced to hire another dredger in order to avoid breaching its contract with that party. Thus, damages which plaintiff sought to recover from defendant in that case included the cost of hiring another dredger and the additional cost of operating it. In Liesbach, Lord Wright found that the damages arising from appellant's impecuniosity and those resulting from respondent's torts were two separate heads of damages. Therefore, Lord Wright held that the respondent was not liable for the losses arising from appellant's impecuniosity because they were too remote and distinct in character from respondent's tort.
Was your client responsible for his own impecuniosity?
He is, yes.
And didn't he create his own impecuniosity through no fault of the respondent?
I believe in this case, considering the fact that appellant, my lord, had only initially offered £400,000, and it was only upon the showing of respondent's valuation was he willing to raise that value to £480,000. I would say there was some force to the valuation which led plaintiff to increase the value of his initial offer.
Is he obligated to buy a home that costs that much?
No, he's not. My lord.
So doesn't that then mean that he's responsible for his own impecuniosity?
According to Liesbach, maybe. However, in Alcoa, my lord, Lord Slynn of Hadley noted that in recent cases, courts have distinguished the Liesbach decision and the principles established in it, and furthermore, courts have sought to set limits on that principle. Thus, Lord Slynn of Hadley concluded that there was no absolute rule that damages that arose from plaintiff's impecuniosity were too remote or that the plaintiff's impecuniosity should be ignored in all cases. In the present case, my lord, I submit that the facts of the case are distinguishable from those of Liesbach. For one, there was no pre-existing contractual duty which conditioned the additional losses between Charles and Bent. Here, it was clear that Charles was simply trying to recover for the differences in the value of the house, which was inflated by Bent's careless valuation. Furthermore, I would submit that Charles' impecuniosity arose from his increasing that initial offer. If not for Bent's valuation, we could presume that Charles would have had another £80,000 to use perhaps on an evaluation.
Isn't there a difference though? In the cases, normally, or for example in the Liesbach, they are forced really to spend that money on the spare dredger because they've got contractual obligations. Yes. Here, he wasn't forced to buy the house,
that is correct.
Forced to up his offer. Does that affect your submission at all?
However, even though he was not forced, like in Liesbach, where the plaintiff had to do so in order to avoid embarrassing his contractual duties, here I would say that it was only a matter of common sense that upon showing an offer that is, or a valuation that is higher than initial offer, that as part of a regular process of bargaining, that there had to be some fluctuation in that offer. It is true that the plaintiff here was not forced to buy the house. However, I submit to you that what happened was, in fact, he had to increase his initial offer.
But isn't it the case that your client did not have an actual contractual relationship with the valuer?
With Anthony.
And did not, was advised by a solicitor to get a valuation. Why doesn't that change the analysis? Why doesn't that cause the court to find that it was his contributory negligence that was the cause of the harm here?
Okay. In Dodd, my lord, Mr. Lord Justice McGaw held that a plaintiff, as far as his duty to mitigate, was not obliged to do that which he could not afford to do. Furthermore, in Merritt's, the Lord in that case noted that if the plaintiff's failure to obtain his own valuation was due to his reliance on the defendant's valuation, then contributory negligence should fail. That is, reliance does defeat any negligence on the part of the plaintiff.
What do we do with the fact, and I assume you accept the fact, that your client's solicitor advised him to get his own valuation? We're talking about a high-value property. What are we to do with that fact?
Again, Charles replied to his solicitor upon that request that he just could not afford to do it. And under the rule established by Dodd, as far as the plaintiff's reasonably behaving in his duty, Dodd stated that a plaintiff was not obliged to do that which he could not afford to do, which in this case, because of his increase in that offer, he was simply lacking in funds to obtain his own valuation. My lord, I was previously dealing with my second submission. In Alcoa, Lord Slynn of Hadley proposed that the proper test in determining whether damages arising from Charles' impecuniosity were recoverable should be whether or not they were reasonably foreseeable. Before I proceed, would my lord like the facts of the case?
No, I think it's all right.
Okay. In Alcoa, Lord Slynn of Hadley held that the defendant was liable for the cost of repair to plaintiff's roof because it was foreseeable that if plaintiff's house was seriously damaged, he would not have the sufficient funds to repair it, and thus his ability to do so would depend on recovering damages from the defendant. In the case here, I submit to you, my lord, that it was foreseeable that Bent's negligent valuation would be relied upon by a potential purchaser. This reliance would likely persuade a purchaser to pay more for the home than it was actually worth. In fact, as we see in the case here, Charles did indeed rely on Bent's valuation, as evident by the fact that he had to increase his initial offer from £400,000 to £480,000.
Are you really saying that the failure of the buyer to obtain any independent advice on the value of the property has no relevance here and has no impact on where liability falls?
as the Lord noted in Merit, if that valuation was due to his reliance on defendant's valuation, then according to the Lord, reliance does defeat contributory negligence. And in this case, I submit to my Lord that there was in fact reliance. Charles, upon seeing the valuation, increased his offer, which was at the time already pretty substantial.
Surely it's a question of whether it was reasonable for you to rely on that other valuation. So it's a case of reliance in a vacuum.
I believe that issue was more properly addressed by my senior. I apologize, my Lord. It was just not the issue I had researched.
Okay, but let's think about it now then. If the reliance on the valuation was unreasonable, surely you have to take into account some form of contributing negligence.
Yes, my Lord, I concede that.
And is it reasonable to rely in a negotiation where the seller's interests are in maximising the property's value and the buyer's interests are in minimising it on a valuation from the other side, commercially, in the real world?
According to my learned senior, 90% of the time the purchaser does in fact rely on the seller's valuation.
Thank you very much.
Thank you.
I'll be responding to the second ground of appeal. Would your lordships like a summary of the facts?
No, thank you.
Thank you. I shall continue. It is clear from the facts that the appellant's loss was due to his own contributory negligence and impecuniosity. In proceeding to the substance on appeal, I have three submissions. First, that there is not a rule that states impecuniosity shall be ignored in cases such as these. Second, that a loss due to the impecuniosity of a plaintiff is not recoverable from the tortfeasor. And third, a plaintiff could only recover damages as reasonably flows from a wrongful act. With your lordship's permission, I shall move on to my first submission. First, it is understood that in tort, there is not an absolute rule which states that damages that resulted from the impecuniosity of an innocent party were too isolated, or that such impecuniosity was to be ignored when assessing damages. Though we're not assessing damages here, this principle is still critical. In terms of the present case, the appellant's impecuniosity shall not be ignored, and the respondents submit that the issues in the case are directly attributed to the negligent actions of the appellant.
How do you deal with your opponent's argument that it was the negligent valuation of your client that caused the impecuniosity?
My lord, I will submit to you that it was not a negligent evaluation that caused impecuniosity. If you look strictly at the facts, it says, I'm pretty sure it's a quote, he was short on money. It didn't say specifically he could not afford it. And if you think about it too, Anthony, the homeowner, was taking a hit on this purchase as well because he, the listed price was higher than the actual price that was paid for. So there was no obligation for him to pay £400,000, £480,000 really to buy the house at all. So this was his own responsibility, his own action. He went about this by himself.
You think if he had stuck to $400,000, the offer would have been accepted?
No. Back to
So you're saying he wasn't impecunious?
No, I'm saying he was impecunious. But I'm saying that his impecuniosity was to his own fault. It had nothing to do with the respondent.
Even though before your client's valuation, he was going to pay 400, and then as a result of it, he paid 480, and then suddenly he could no longer afford a valuation on his own.
But back to my point, he didn't have an obligation to do any of it. I understand it would have been easier for the deal to go through without getting the valuation, but anyone who's purchasing a home, whether for themselves, for their families, doesn't matter who for, should exercise reasonable due care when making those types of purchases.
Well, there's two different points there, isn't it? So first is a point of causation. So, but for your client's valuation, would he have upped the price? The answer is probably no. And then there's a question of whether it was reasonable of him to up the price, which it goes to contributory negligence, doesn't it? But the Professor's question was, is the impecuniosity as a matter of causation caused by your client's negligent valuation?
respectfully, my lord, we don't have enough facts to understand that issue. It very well could be true, but it very well could be false. I'm not sure.
Okay, thank
To
you.
my first submission, or back to my first submission, rather. Appellant's impecuniosity is directly at issue here because if not but for his impecuniosity, none of us would be here today. In 2000, in the case of Alcoa Minerals of Jamaica against Herbert Broderick, which you can find behind the green tab in the bundle, the Privy Council held that the plaintiff's waiting to complete repairs to his home was reasonable because he was waiting for Alcoa to admit liability and did not have money at that point in time to make adequate repairs. The plaintiff was acting prudently, whereas in the instant case, respondent was not acting reasonably prudent by any means. Distinguishable from Alcoa, there was not property damage from a smelting plant or any other direct consequence of outside
Was
factors.
your client acting reasonably prudently in providing a valuation that clearly missed the mark in terms of the actual value of the home?
My lord, I don't think that my client intentionally provided a misvaluation, if you will. I think he was doing his best. He found their local valuer who's done this for I'm not sure how long, but everyone knows him apparently. And I don't think it was his intention to get a bad valuation.
But he did give a bad valuation, didn't he?
Yes.
It was negligence.
Yes.
Right.
Well, I don't think he could have foreseen that. Rather, I don't think it was his intention to get a bad valuation. It just happened.
We can
Yeah.
accept that, but nonetheless, it's a poor valuation, isn't it?
It would appear so.
And what he could foresee is the need to put a disclaimer into any valuation that's provided. He could have, as a professional, done something, if he's acting reasonably prudently, to distance himself from liability to somebody who might rely on that valuation in purchasing a home.
I agree, my lord. It just didn't happen here. Okay. Sorry. Appellant refused to obtain a valuation of the property he was purchasing, an act which was in his own power to do. It was also noted in Alcoa on page 373 that increased loss caused by impecuniosity of a plaintiff will generally not be recoverable from a tortfeasor. This rule does not impose a penalty for impecuniosity, rather it does not allow impecuniosity to be a benefit. We here are not asking for a penalty for the impecuniosity of the appellant, but rather that the appellant does not use his own impecuniosity in order to unfairly recover and benefit from Mr. Bent.
Okay, going back, I don't want to go on to what I said before too much, but would you accept that if the impecuniosity was caused by your client's conduct, then it would be recoverable, but if the impecuniosity is somehow independent of your client's conduct, then it would be a different matter?
I do agree with that statement.
Right.
It is submitted that, as a natural and direct consequence of his impecuniosity in the matter at hand, the appellant did not act as a reasonable, prudent person who's buying a property would, as I had mentioned before. In order to save money, he disregarded the measures he should have taken prior to purchase, and then discovered the defects on the property subsequent to his purchase of said property, and because of this is not entitled to recovery.
Your opponent has told us that 90% of buyers rely on the seller's valuation, so why do you say that what happened here was unreasonable? Or do you disagree with what he says?
I don't disagree with what he says, my lord. However, I think that everything should be taken by a case-by-case basis, and I just know anyone who is taking reasonable matters in purchasing a home should be doing his due diligence and discovering what's wrong with the home. I don't know if your lordship would go and buy a home and not do everything possible to make sure that it was what you were paying for.
So their lordships are just wrong when they say, well, 90% of people would rely on that single valuation, and that's fair enough.
I'm not saying your lordships are wrong, but these cases do climb up the ranks, and some things are overturned sometimes, so it could be determined differently in your lordship's opinion.
If it's not reasonable to rely on the seller's valuation, doesn't that undermine, as a matter of public policy, the responsibility of any professional individual in this area of work to make sure that their valuation is spot on and not partisan? That's the corollary of what you're arguing.
I'm not saying, my lord, that it's not reasonable to rely on valuations, but if there was property damage, significant property damage, as the facts make it seem, even if the appellant would have walked into the house, it seems as if he would have seen that everything wasn't £500,000 worth of value to the home.
But then shouldn't your client have observed the same thing? Your client's a professional. Why should we hold a layperson to a higher standard than we hold a professional?
My lord. Because the layperson, with all due respect, is investing this money in this home for whatever reason. I'm not saying that it's not negligent of my client to be doing this, to give a false valuation. However, my point is that the contributory negligence could assisted in his loss, and well, his contributory negligence due to his impecuniosity assisted in this loss, his loss.
Do you think it completely eradicates your client's liability, or should there be some kind of apportionment?
So, could you repeat the question, maybe?
If there was contributory negligence here, does that get your client off the hook completely, 100%, or does it just mean that there should be an apportionment of liability between taking into account the contributory negligence and the negligence of your client?
Truthfully, my lord, I'm not as well prepared in contributory negligence in English law.
Common sense proposition, doesn't need any law.
I mean, I would say it's not going to be a whole on part of one or the other. I see my time has run up. Can I briefly conclude?
Just finish the point.
Okay. It's nobody would have to be giving 100% of either, damages or taking the loss. So I think that would be up to your lordships to determine. And thank you for your time.
Thank you.
Well, that's important.